think we can get started. It's really a great pleasure to welcome again so many of you for our CF webinar today, where we want to give a general EPO case law update 2020. And we just picked decisions which seemed interesting for us, that is myself, Nathalie Kirchhofer. I'm a biochemist by background, patent attorney and partner here at Coors and Flora. And to the right, maybe introduce yourself, Matthias.
Yes, I'm Matthias Carlem, also a patent attorney and partner here at Coors and Flora. I'm a mechanical engineer from the outset, but I do a lot of cases in the medtech space, software, etc. So quite diverse.
Yeah. So that's also reflected in the selection of cases that we picked for you. You will note that there are some more chemistry or pharma related cases, and then there are others that relate to electrical engineering. But we picked cases where we think that irrespective of your technical background, you might find a couple of interesting things to note for your own practice. And our agenda today is pretty straightforward. So we structured it in this way, that we first will tell you about this year only 3 cases that are before the enlarged Board of Appeal. One has been decided, only one this year so far, G3 of 19, and there are 2 referrals pending. We then picked 3 cases from the Legal Board of Appeal that were decided this year, and then comes the main part of the talk, where we really just hop through a couple of interesting decisions. And maybe also from the outset, maybe some of you are also particularly curious to know how the Boards of Appeal in 2020, which is the first year now that the new rules of procedure have been in place, have ruled on procedural matters. We actually put all of those decisions into a separate webinar, which will take place on December 7th. So today there will be no or almost no procedural points that we will note. That's reserved for the December webinar. And with that, let's dive into our first decision, Matthias.
Yes, thank you, Nathalie. So a warm welcome from me as well, again. So the first decision, well, it's not yet a decision. It's a pending referral before the enlarged Board of Appeal, and it's on computer implemented inventions, which is a hotly debated decision, that eagerly awaited decision. The hearing took place in July this year. It was the first time that the EPO provided a live stream for the public, i.e. the media and the public, and it's going to be very, very interesting what they say. So, and it is in the space of, as I said, computer implemented invention. It's about a computer implemented simulation, which is claimed as such. So I won't read the questions, because you can do that yourself. But the system is a simulation, and what is claimed is a simulation of autonomous entities, people moving through a building, a structure, and this is it. So it basically claims a chunk of software running on a computer. And the question was, to the enlarged Board of Appeal, can this be something, a technical solution that solves a technical problem by providing a technical effect? So a chunk of software running on a computer, can this be considered technical at all? Because it doesn't go beyond the computer, it's just claimed as such. So this is the first question, and you can imagine this is not just important for computer simulations, whatever. This is, and this is why so hotly debated and long awaited. This also applies pretty much to everything that is in the artificial intelligence, machine learning space. So everything that just happens on your computer, is that accessible at all by providing some technical effect? And that's basically the first basic question. Can this produce a technical effect at all? And does it solve a technical problem? And then they said, okay, if the answer is yes, they asked, oh, and what are the criteria to find out if this is technical or not? This is the second question, the second important question. And a sub-question to that is it good enough, for example, that the simulation is based on technical rules, technical principles or whatever. Is that good enough to provide this technical solution, technical effect? And then the last question that is asked is basically, yes, and what if this is not just, if it just doesn't claim the simulation as such, but if it goes beyond the simulation, it goes beyond the computer, for example, by encapsulating it in a design process and saying, okay, so by having a grasp to the real world, basically. So and these are the questions, everyone's eagerly waiting for it, and let's see what they do with it. So very, very important for the AI space as well.
Yeah, and the second referral that is pending concerns a double patenting situation, and this I think is very exciting to see what the enlarged board will make out of it. So far, the enlarged board has never ruled on double patenting. In its decision G2 of 10, it made an obiter dictum where it said that in general, it should be possible for an applicant to, for example, obtain a more narrow scope quickly, and then in a divisional application, a more broad scope. But now we have a referral here before the enlarged board, which really concerns identical claims. And in this case, a priority application existed, which led to a patent. And then the later on filed application here was pursued with identical claims. And the question is, if here the patent proprietor has a legal interest in obtaining the second patent, although it really contains identical claims, and the legal interest could be justified because, of course, the later filing would give an additional year of patent protection, because the 20-year term is calculated from the filing date, not the priority date. But as you see from the questions here, they are worded more broadly. It remains to be seen whether the enlarged board will also discuss the issue of double patenting more broadly, or will limit itself to this very specific case, as it sometimes does. But I would say it's highly relevant for the practice, and we've actually had a lot of our prosecution cases stayed pending decision on this case. The only decision that was rendered this year by the enlarged Board of Appeal was the G3 of 19 case, shorthand keyword PEPA. It concerns the patentability of plants and animals obtained by essentially biological processes. And I don't want to go into the details, the biology behind it and so forth, because I know a lot of you among the listeners are not biotech people, but I think it's noteworthy mentioning this decision and going through it, because it has a very peculiar history and a very peculiar way this decision actually came about. Because as you can see from the timeline here, G3 of 19 issued this year is also, I think, the first in the history of the enlarged board where it directly reverses an earlier decision. So the head note of G3 of 19 is directly contrary to the head notes of the decisions G2 of 12 and G2 of 13. And you can ask yourself, well, what happened in the last 5 years that the enlarged board reverses its position so crucially? And what has happened is actually a legislative change, but only on the level of the rules of the EPC. So Article 53b, which contains this provision that plants and animals obtained by essentially, that essentially biological processes to obtain plants and animals are barred from patent protection, that did not change. But what did change is that the EU Commission was not very content with the G2 of 12 and G2 of 13 decisions, and issued a notice stating that in its opinion, the Biotech Directive should be interpreted as prohibiting product by process claims for plants and animals obtained by essentially biological processes. And this then prompted the Administrative Council, although it's also not bound by EU law, and although this notice itself also doesn't have any legal effect, to draft a new Rule 28.2, and the wording of this new Rule 28.2 was exactly the contrary to what was decided in G2 of 12 and G2 of 13. So in a way, the Administrative Council tried to directly revert the decision of the enlarged Board of Appeal. And then this, of course, led to a lot of examiners implementing Rule 28, because that's what they are supposed to do. And this was then appealed in a couple of cases, and in this seminal decision T 1063 of 18, this was the first Board of Appeal which declared Rule 28.2 to be void, because it's in direct conflict with the earlier enlarged Board of Appeal decision G2 of 12 and G2 of 13. So it declared the rule invalid, and now comes kind of the final turn of this whole story, which is really remarkable. Instead of accepting this decision of the Board of Appeal, the EPO president referred a question to the enlarged Board of Appeal, whether this, in a way, could be the case that the Technical Board of Appeal declared the Rule 28.2 EPC void. And there was a lot of speculation about whether this referral is admissible at all, because actually usually the president is only allowed to refer questions if there's, for example, conflicting case law and so forth, but there was no conflicting case law. But very curiously, the enlarged board accepted the referral and actually also ruled in favor of the president's opinion. So stating for the first time that enlarged Board of Appeal decisions, the interpretation of the articles of the EPC is dynamic. It can change over time, and in particular, it can also change by mere rule changes. So that now puts a lot of power to the Administrative Council, which in a way, if it's not content with the case law of the Boards of Appeal and enlarged Board of Appeal, can just implement via rule changes a new line of case law. So that was viewed very, very critically. It did put into place a transitional period, but still, in our opinion, this is quite a setback to the separation of powers and also to the power and independence of the Boards of Appeal and the enlarged Board of Appeal.
So to remember, just peppers win over tomatoes and broccoli.
Yeah.
So that's the thing to remember. So now we go for some decisions of the Legal Board of Appeal. And the two I'd like to mention is J3 out of 20, which is, well, interesting. Some might say, yeah, okay, that's logical. It's about the designation of designated states in a divisional application, and in very short, what the board decided is the designated states in the divisional applications are defined by the designated states in the parent application at the time of filing the divisional application. So in that particular case, the parent application had abandoned one state, effectively abandoned one state. So the divisional application was not entitled to designate that state anymore, just in very short to that. But this is something certainly to remember if you consider abandoning designated states or potential divisional applications. So this may have a long-term effect on what you can cover in divisional applications. The next one is a very interesting one as well. It's J7 out of 19, which is the withdrawal of an application is hard to correct under Rule 139 EPC. So what happened? An applicant had positively, actively withdrawn an EP application, but at some point they figured out, oh no, that was a mistake. We didn't want to do this, and they tried to correct it. But the board ruled, okay, at the time of filing this declaration, of filing the withdrawal with the EPO you actually wanted, you had just decided, the decision was made that you actively wanted to withdraw it based on errors, whatever, but that's just the reasons for why you did it. But at the time you filed the withdrawal, this was your intent, and that's what counts at the end of the day. So you couldn't correct it under Rule 139 EPC. That wasn't possible. Another thing that came into play in that decision was the public was already notified, so the withdrawal was already at the register. So everyone out there could find out this application had been withdrawn, and that also added to it to excluding a correction by Rule 139, because at that point it's not possible anymore. And then what the applicant tried to do is file a declaration which said we won't assert any rights against anyone who rightfully started using the patent, but that didn't work as well. So no matter what it is, if it is your positive will, if the declaration is not filed in error, but it was your positive will to file that declaration, then it's virtually impossible to use Rule 139 to recover an abandoned application, which is bad, but yeah. It is what it is.
Yeah, the last one of the J decisions here is a really complicated case, and it's beyond the scope of this webinar to go into the intricacies of this case, but it shows you how things can go and how things can also go wrong. It concerns the case, an opposition case where the proprietor was a joint proprietor, and one of the joint proprietors needed to file for bankruptcy, or there was at least a case of insolvency, and actually the EPO of its own motion learned of this insolvency from a different file, and then issued a decision that the proceedings in the opposition case were interrupted pursuant to Rule 142 EPC. So here the patentee itself in the opposition proceedings did not actually request the interruptions, but the EPO did it at its own motion. And what you will see in a moment, what makes it complicated is that this interruption of the proceedings takes retroactive effect, right back to the time where the legal incapacity started. And here the peculiar thing is that the opposition proceedings went on, and actually there even was a first instance decision. So you see here in September 12, 2017, there was oral proceedings in the first instance, and the opposition division ruled favorably for the patentee and upheld the patent in amended form. And only after that, the EPO interrupted the proceedings. The patentee, there are two appeals here. So the parties appealed the opposition division's decision, so that's why appeal proceedings started. And this is then the case T1389 of 18, where the Board of Appeal in the opposition case said, well, there's nothing to decide on here because due to the interruption that issued in the meantime, the first instance decision became void. So that's why they remitted back to the first instance. But also the patentee disagreed with the interruption as such, because it said it's a complicated case. It said that there was actually no need to interrupt, so it questions this insolvency situation. And it appealed the decision to interrupt and requested that the reversal of the interruption also be made retroactive, so that the first instance decision remains valid. Because in the meantime, the patentee had sued competitors for infringement who had joined the opposition proceedings as interveners. That's why it was in the patentee's interest to have this first instance decision, which was positive for the patentee, but the legal Board of Appeal here said no, whereas the interruption of proceedings takes place ex tunc, so with retroactive effect, the resumption, no matter whether the interruption was justified or not, can only take effect ex nunc. So what you can learn from this is that insolvency cases can become very complicated. You can also learn from it that apparently the EPO also takes action on its own motion. So I think patentees should be well advised if you learn that you're a joint owner or yourself, there is some insolvency situation or rumors about it. You should proactively inform the EPO that no interruption is needed, appoint a representative, and so forth, but not just let time do its course, because that can also really go wrong, as in this case.
The takeaway: just don't go bankrupt. That's the best thing to do.
Also good advice.
I think that's a fair advice. So the next thing is something which is really important, I'd say, and many people out there in the field are not really aware of that. especially with the new rules of procedure of the Boards of Appeal. What we had here, it was a case where an opposition case where an asserted public prior use was asserted. The opposition division found that it was not sufficiently substantiated during the opposition. It's a very it's feasible, but you just have to follow the rules to show public prior use. At the end of the day, the OD rejected the prior use, and the opponent apparently filed an appeal, but and as you may see, the grounds of appeal were only 6 pages long. And all they did was basically they only focused on the issue of why they were wrong in not finding their public prior use sufficiently substantiated.
So that it was made public, right?
That it was made public, that it was what it was. It's the W questions for public prior use. Who did it? When did it happen? What was disclosed, and to whom? Basically, so that's the things that you have to follow. You have to typically with many public prior users, you just use witnesses because there is rarely a complete chain of proof for all the things that you want to show. So typically it's with witness hearings, etc. But at the end of the day, for that appeal, as the grounds of appeal only addressed particularly that point and did not relate to all the other issues, why, okay, there was the public prior use and then there were only even parts of the prior use that were addressed. They did not refer, for example, not refer this public prior use shows this, that, this feature, but just only very singular points. And the Board of Appeal found, no, you did not sufficiently substantiate your appeal, which means it's inadmissible, which is, well, basically, you see the rules over here. So it's Article 108, Rule 199 and 101, which are the two that say, okay, the one you have to lay out your complete facts, not just on one single point you lost on, but the complete story you have in an appeal. You have to tell the complete story, which is rarely told in 6 pages. So this is it. And on top of that, the new Article 12 rules of the procedure of the Board of Appeal also says you have to lay out your complete case, everything. Okay, start from the beginning up to the very end, lay out everything, because all other stuff that you provide later on, or which is very popular, but not the right way to do it. Just refer to what you have said in the first instance. No, don't do this. Just tell the whole story in one single document, which is either for the appellant, the grounds of appeal, or for the appellee, the reply to the appeal. You have to tell your full story. Otherwise, you might be toast if you don't do this. You might have trouble bringing further arguments in there, or it may even go that far that they say it's not your appeal is not admissible because you didn't lay it out. A similar case is the one that we have down here, where it was the case that a decision had several alternatives why they found a claimed subject matter lacked patentability, and the patentee apparently just referred to one of those alternatives. And they also said, yeah, you didn't address everything that was basis for the decision, so not sufficiently substantiated, inadmissible.
Yeah, and I mean, the downside, of course, of the inadmissibility is always that there's really no way to heal it, right? Yeah. Even under the strict late filing provisions now, if your case is inadmissible, there's nothing that you can do about it. Yeah. Yeah, we already talked briefly about intervention in this strange insolvency case. This is another case about intervention of the alleged infringer. And it just shows you, or again, reminds you maybe of the basic principles. So the intervener joins as an opponent. What happens if the case is already on appeal? Then and that has been decided before, the intervener joins as a party of right, so like an opponent that did not file its own appeal, but it is a party of proceedings, and it can bring its opposition case, so to say, also during these appeal proceedings. What this decision here now, T1665 of 16, put down very clearly is what happens with new attacks, new documents, new lines of arguments, and so forth that are brought by this intervention during appeal proceedings, and actually took a very clear stance on this, that there's really an all-in approach. So if you're an intervener, even if the case is on appeal, and even if it's very late in the appeal proceedings, you can put in a completely new case. You cannot raise new grounds of opposition, but you can put in really new documents, new attacks, and so forth. And there's no way for the board to hinder you there. So the board here stated that it does not have any discretion to reject these submissions. They were filed as early as possible by the intervener with his intervention, and that's why they are not late filed. So everything comes in. This case is then interesting for another reason, because actually the intervener withdrew its intervention. And here from the case, not having looked at the prior art in detail, but it seems that the meat on the bones of these opposition attacks was in the intervention. So these documents E1 to E20. So I don't know, probably the parties settled in the litigation and the intervener withdrew its opposition in the intervention. And the patentee might have thought that then maybe the attacks also go away, but they didn't. So the Board of Appeal stated here that once the intervention has been admissively filed and the documents are admitted, it's not as if they would go away if the intervention is withdrawn. So what implications does this have? It has interesting implications. So the first implication we thought of when we discussed this, but we're also happy to hear your thoughts on this, is as an opponent, if you anticipate that you might be sued by the patentee, and that's why you're opposing, you might think about filing the opposition not in the name of the entity that might be sued, right? So you could file it via a strawman or via a daughter company, or maybe your IP holding company, where you think those will not be the defendants in the litigation. This has the advantage that you have two bites at the apple, so to say. So you can file your first opposition, and then later on, once you're sued in the litigation, the real party of interest, the defendant, can join as an intervener. And then, you know, with hindsight knowledge of what worked or what didn't work, or with an additional search, you have an additional shot to get attacks in. As a patentee, what I didn't mention is that the case was then remitted to the first instance, because of course on appeal, these documents and attacks had not been, in the first instance, these attacks and documents had not been discussed. So that's why also as a patentee, you should think carefully whether you want to assert your patent during pending appeal proceedings with a new defendant, because that will very likely lead to a remittal of the case, also under the new rules of procedure, which state that the appeal proceedings, right, are primarily a judicial review of the first instance decision. If you have a completely fresh case on appeal by an intervention, also under the new rules, we expect that this will lead to remittals. So this gave at least us some food for thought for possible strategies in opposition. And I also take on the next one. I'm sure you are already aware of this decision. The oral proceedings were in January. It's the foundational CRISPR patent of the Broad Institute, MIT, and Harvard, which was invalidated by the EPO in first and now second instance due to a formal defect in the priority. Right, you're all aware probably of the same applicant's approach that the EPO requires the priority applicants. All of these, all their successors entitled, all of them to be among the applicants of the later filed application claiming priority. And this was confirmed here after a very furious battle fought by the patentees with a really horde of experts and so forth. What is a bit remarkable here is that's why I also put it in again, this decision, is that actually the full reasons for the decision only came out last Friday. So more than 10 months after the oral proceedings, which is peculiar. There are rumors that the patentee here might file a petition for review. Also, the register shows activity like a request for correction of the minutes, which is always a relatively good indicator for a potential petition. Another reason could be, and that's something we followed very closely, is that there are a number of other appeals pending where actually the boards are more inclined, so different boards than this one here, where the boards were inclined to take a different position on priority, so which might lead to a referral in the end. And there was one just 2 weeks ago, a very big case, the Amgen Regeneron PCSK9 litigation patent case, where exactly this issue was at stake. And it might also be that the board wanted to wait here and not issue its decision before, but it's definitely worth a read, but in principle, nothing much surprising. It's the consistent position, very strict on formal priority. And if you're interested in that topic, we put in here the link, or maybe also Christiane can put it into the chat. We had 2 webinars with Professor Hedeke and one with Christopher Rennie-Smith, which discussed these issues regarding formal priority in very much detail. And you can see the recording in our blog.
Good. That brings us to the next case, which is interesting in terms of what you can really discuss before the EPO. And this particular case, as you see it, they decided that useful for is not the same as suitable for. And I'll give you another example in a minute. So it was in opposition. The patentee obviously changed or made the amendment which said that a liquid absorbent structure is useful for absorbent articles. And as always, if that amendment doesn't come from a granted claim, it's always on this. This always opens up the discussion for clarity. Is this amendment meeting the requirement of Article 84 EPC clarity? So basically, there was a discussion, and which ended up in the result. Useful for is not the same as suitable for, which was something that you had in the possibly had in the specification, and the EPO thinking is, okay, useful for is a bit more than suitable for. So useful for has a particular effect, a particular benefit for this article, which contains this this useful element. So it shows you can go very deep into the details with the EPO. And then they said, okay, suitable for is just general suitability. That is clear enough. So anything that can absorb liquid is perfectly fine and is suitable for doing this. But useful for suggests something more, something beyond that. And the claim doesn't show what that something more, that beyond that additional benefit is. So it's unclear, and this is why they rejected it. A similar case I have, which is not on here. It was we actually lost the patent, which was not prosecuted by us, but at the end, on the difference between prohibiting and preventing. So someone during the grant procedure had the good idea to write prohibiting something, a system prohibiting something, although the spec only showed preventing something. And the EPO said, no, prohibiting is something else than preventing, because if I prohibit you from going through the door, I say you don't go through that door. If I prevent you from going through that door, I lock the door. So this is the difference. And they said, that's it. It's not the same thing, and we couldn't change it back. It was a 123.2 trap, because then if we had put in the preventing instead of the prohibiting, then they said it's something else. So we lost the patent on precisely that difference. So it's just a reminder to be extra careful what you put into your claims, especially during prosecution. Be extra careful that it's there, and you may end up with discussions like that.
Yeah, it definitely shows that there are at least many members of the boards of appeal which really enjoy these linguistic analysis, and it also shows you that you should just try to attack clarity also. I think this one, useful for absorbent articles, I personally would have not
at first glance you would have
a
said
clarity objection here, but you see that it was worthwhile for the opponent in this case. The second clarity case that we picked for you, again, just to give you a flavor of what the Boards of Appeal rule on in terms of clarity, is this one which concerns the pharma case. And actually, if you read the claim, a pharmaceutical composition comprising an activated potentiated form of an antibody A and B, an activated potentiated form of an antibody B to a different target. Actually, when I first read this claim, I also didn't think of what it actually meant when you then read the description or the decision, and that should show you that indeed there is an unclarity here, because what it actually relates to is a homeopathic medicine. So the activated potentiated form is not in a way molecular biology or some technical activation, but it's actually what you know from homeopathy, from globally, the dilution steps and stirring steps and so forth, where the homeopathy does its magic and then it becomes potentiated, as the homeopathy experts, doctors say, yeah. And here, curiously, the EPO killed this patent on clarity, because it said that this activated potentiated form, although the description actually contained explanations on these homeopathic methods, how to prepare a homeopathic medicine and what is meant by activated and potentiated, the EPO still considered it here to remain unclear. It would relate to a method of preparation, so these diluting steps and mixing steps, and that this method was not clear. But in my experience, at least, it's one of the rare cases of the EPO that actually deal with homeopathic medicines. That's why we put it in here.
Okay, so now we go to the other end of the spectrum, artificial intelligence, neural networks again, which are very popular, as probably most of you know. And it's quite interesting here to see. The claim was essentially about calculating cardiac output, so the output of your heart, based on the aortic on the pressure waveform, basically. And what it did, there was a transformation of what you could measure into the cardiac output. And all the claims said this is done with the aid of an artificial neural network, and which is trained. And that's where not only the claim ended, but basically the disclosure ended. So the board said, no, this all of that is not good enough. You have to give a bit more information than just bolting artificial intelligence to what you conventionally do. So this is not good enough. So you have to provide a bit more than just saying, oh, I'm using AI, that's it, done, perfect. So that's one requirement. That's Article 83. So sufficiency of disclosure. You have to disclose how to do this rather than just claiming we do it. So this is the one thing. And then the next thing is inventive step. If you just, as just said, bolt artificial intelligence to whatever you do, then this is not good enough to justify an inventive step. It doesn't have a special technical effect as such in all that breadth, unless you provide some specific technical magic to it, which really does it, and you disclose it, what you do. This is something that is absolutely required in order to justify inventive step.
Yeah. And again, actually, just last week, right, you maybe saw it in our announcement, we had a special seminar on computer-implemented inventions, which also discusses this decision in a bit more depth, in case you're interested or want to have a general introduction into the topic. These two decisions here, we pulled up more for the chemistry or pharma people among you. There were two decisions in 2020 on interesting decisions on polymorph cases. Right, the key polymorph decision is still T777 of 08, which viewed polymorph claims rather critical, as being routine development steps in the development of a pharmaceutical. When you talk about oral dosing forms and develop a solid form pharmaceutical, then it's obvious or even required by regulatory authorities to look for a thermodynamically stable polymorph form. But nevertheless, there has been a line of case law that has acknowledged inventive steps for polymorph cases, and we listed them out here. In each of these cases, there always needs to be some sort of non-obvious property of the polymorph, which is then non-obvious if you formulate the objective technical problem, the problem solution approach, as wanting to obtain really a polymorph having these properties. But it still remains very complicated and very difficult to predict. And this you see if you compare these two decisions that we put down in more detail here from 2020. They are from the same board 3302 Chairman Müller, and even from the same rapporteur, Bertrand. And within 2 months, he reached completely different decisions in cases which, well, at least share some similarities, and you actually really need to go into the decisions in detail and the prior art situation to try to understand better why inventive step was denied in the one case and inventive step was acknowledged in the other case. Just briefly, what seems to drive here the rapporteur a bit is perhaps also the prior art situation. So in the T41 of 17 case, the prior art only disclosed the compound as such and didn't comment on any crystal or polymorph forms. So then it reads between the lines that it is then obvious to at least search for one polymorph form, whereas in the second case, the prior art already disclosed a specific polymorph form, and the claimed polymorph form is then the further polymorph form, and it even seems that it's easier to get a patent if you have a situation where you already have polymorphs and then are developing a further improvement in a way that the skilled person is not motivated if it already has a polymorph to search for an improved polymorph. But the devil here really lies in the detail, and I think it's fair to say that polymorph cases remain very difficult to pursue before the EPO, and that a detailed case law analysis really needs to be performed to understand whether your case has merit here.
Okay, the next case, which is about something you well love to discuss and always have to discuss in opposition, is the objective technical problem. And well, just very quickly, what I'd like to take away is what was in the patent, what's formulated in the original disclosure was basically the solution. So they essentially said the problem is to come up with the solution, or the problem is finding the solution. So this is something you definitely shouldn't do, because you'll always be confronted with by the opponent with hey, yeah, you say it yourself, this is the problem and this is what you do. Never do that. Never write the solution into the problem, basically yourself. The next thing is what the boards of appeal, and especially in my field, typically tend to do, or also the opposition divisions, they reformulate the objective technical problem. They do not care that much, which is only fair, about what you wrote back then when you filed the application, when you drafted the application. But what is the real objective technical problem? That may be a completely different one, starting from the closest prior art. So this is basically, so the takeaway from that: don't write the solution into the problem yourself, and don't accept, on the other hand, as a patentee in opposition, that they try to nail it down to what you wrote into the patent application, but try to come up with a reasonable, more objective, more general OTP, objective technical problem, that you write into your patent application.
Yeah, now let's turn to added matter, and we picked this decision because it's kind of some light at the end of the tunnel, at least for one decision which is not so super critical. Here it's about the disclosure of a combination of features, the EPO's two-list principle, which in the more recent case law has become ever more strict. So we put in the final line of this slide here a series of case law, mostly by one particular board, but now you see that actually other boards are adopting this as well, which considers the standard phrases in patent applications that so you have a claim for a composition with A, B, C, D, and then the description sets out for each of these components, for example, preferred weight ranges, preferred particle sizes, and then you have these clauses, preferably A is this, more preferably, even more preferred, and then most preferred. And these decisions down here, they consider these levels of preference statements as lists. So as soon as you then limit your claim A, B, C, D composition by two of those features, you're already a selection from two lists, which is no longer disclosed. And that's why we like this decision here, T31 of 42 of 19, which at least contains this general statement that even if there's no specific pointer to the particular combination claimed, that does not automatically mean that the combination is not derivable by the skilled person based on the application, because of course usually the whole sense of this preferably, more preferred, and so forth is because you want to indicate that you want to be able later on to pull these features into the claim. But certainly in drafting applications, it might make sense to put wording in that you also want to disclose combinations of different preference levels, because the curious thing what these decisions down here do, what most of them consider disclosed is if you pick from the same preference level. So if for all of A, B, C, D, you always pick the third level of preference, so for example, the most preferred or the more preferred, then it's fine. The problem, what they see is with mixing different preference levels, which in our opinion is really an extremely formalistic approach, and it gets really ever more difficult to explain this also to non-EPO resident clients, which really feel that that the EPO is going berserk here. Yeah, good. Then just a short note on disclaimers, because those are there are two issues with disclaimer in the disclaimer case law that we just wanted to point out here. The ruling case law here still is G1 of 03, which sets out the criteria that need to be fulfilled for undisclosed disclaimers. So for example, if you have a post-published pre-filed Article 54.3 document, right, you can restore novelty by putting in a disclaimer, for example, disclaiming a particular example. And one of these criteria is 2.4 here, a claim containing a disclaimer must meet the requirements of clarity and conciseness of Article 84 EPC. And this is often a huge problem, because with your disclaimer, you are usually verbatim taking, for example, an example from a prior document and putting that into your disclaimer. So the wording of the disclaimer is governed by the prior document, because also 2.2 here, a disclaimer should not remove more than is necessary. So you're really only allowed to remove that example. But what if this example is worded in an unclear way, right? And you have this 2.2.2.4 trap here. And there are decisions which have said that the criterion 2.2, because that's based on Article 123.2, should overrule the clarity requirement. But what I just wanted to point out is that there are now decisions out there which confirm that the clarity requirement in 2.4 is not an additional criterion, but it is the Article 84 criterion, which also means that it does not apply to disclaimers that were already introduced in examination. Yeah, so disclaimers that are in granted claims cannot be attacked based on G1 of 03 reason 2.4, because what many people forget is that also this G1 of 03 case concerned a disclaimer that was added in the opposition proceeding. so that's the one thing. And the other curious thing I just wanted to point out in the T1532 of 16, which was one of our own cases, there the opponent suddenly started attacking the disclaimer, saying that the disclaimer was non-enabled because it was so unclear. So clarity was then off the table because right, it was disclaimer and examination, and then he said, well, okay, the clarity I cannot argue, but it's so unclear that it's not enabled. And there you have to think a couple of turns, but if the disclaimer takes away subject matter of your patent, so it's not the subject matter you want to protect. So actually Article 83 does not apply to disclaimer because that's what you're excluding. And the decision, the chairman found its own words to describe this. He puts it very clearly that, of course, the disclaimer excludes something, and if the disclaimer doesn't mean anything, then you're also not excluding anything, and then you cannot violate Article 123.2. So I think it's an interesting disclaimer decision.
So yeah, another thing you can perfectly talk for hours about is common general knowledge. Two things I just like to highlight with that decision is basically, which people tend to forget, public prior use can be, of course, as any written document, be prior art, and it can be the starting point for inventive step, and you can combine it with common general knowledge. So this is once you've shown it, you've proven public prior use, you're fine. You can do anything with it that what you can do with others. The only caveat here is public prior use does not contain any pointers. So it doesn't, as we always or often have in the closest prior art document, it points, you have something written in that document which points in certain directions. Public prior use typically does not have that. It's just an element. It's just, an iPad or whatever like that. It doesn't point anywhere. So this is something to consider. And then, that's why we highlighted it there. What is common general knowledge? And the board said, okay, you can apply common general knowledge. You don't have to provide a particular reason. I would put that into a bit into context. If what you're using, the common general knowledge, is not directly related to what the issue is, it's a bit far-fetched, maybe common general knowledge, but not immediately related, you would need to show why you would look there remotely. But if it's in the same space, you need no motivation for applying common general knowledge. It's just there, the skilled person has it. And if it deals with a particular element, which is the closest prior art, then you don't have to argue why one skilled in the art would apply it. Yeah. So these are the two things. Public prior use doesn't point anywhere, and common general knowledge in that particular field does need no justification. Yeah.
But I think it's definitely a nice decision to cite as an opponent if you use common general knowledge. And then our last decision for today concerns second and further medical use cases. That's the EPO format compound. So, for example, an active pharmaceutical ingredient of a drug for use in treating a disease, and that's laid out in Article 54, 4 and 5 of the EPC. And these articles speak of substance or composition for use in the forbidden methods of treatment. And there has been a lot of case law on substance and composition that it really needs to relate it to a chemical substance or a chemical composition. Of course, you can say also medical device, anything is a substance or composition, because of course also the stent or whatnot is made of a polymer material, which is a chemical composition. But there the case law says even with physical things, the treatment effect needs to reside in the chemical nature of the substance or composition. But there are always cases that are at the threshold or not so easy to decide, and this is one of these hybrid cases because it concerned a synthetic lubricant for use as a replacement for synovial fluid in diseased joints. So of course it's a chemical, the lubricant, but on the other hand, it's the very purpose of a lubricant to be chemically inert, so it's definitely not an active ingredient, but this was allowed here. The board stating, even though it doesn't underlie the same regulatory principles as an active pharmaceutical ingredient, still the technical effect here resides in the chemical nature of the lubricant, and that was the invention here, particular lubricants, and that's why second medical use claim was allowed here. Yes, and I think this closes our tour de force through a lot of different decisions, but we wanted to just give you an update, as the title says, and some food for thought. We hope that there were interesting decisions here. As I already mentioned, we didn't cover the procedural aspects of the new rules of procedure because we reserved a whole hour for this in December, and just as a teaser, we've really done a very thorough analysis of the cases, a lot of cases which touch on procedural matters under the new rules of procedure, which we will present in our December webinar, and you can still register for this on our blog or by just responding to the email you received for this webinar. And with that, I want to thank for your attention. Matthias and I will still be available for the next 15 minutes or so. We will, yeah, maybe if you would like to register or receive invitations for future CF webinars or seminars, you can also register for our invitation list. Yeah, and this concludes, I think, the formal part of the webinar.